In this video, we're going to share 5 tips for divorced people with minor children. Grab a pen and paper because you're going to want to write these down. We know this is a moment in life where everything feels both raw and uncertain. You're rebuilding, you're recalibrating, and you're realizing that some of the most important decisions you'll ever make have nothing to do with custody schedules or financial settlements. They have to do with what happens to your kids if something happens to you. That's where your California estate plan, and more specifically, your living trust, comes in. With this in mind, here are 5 powerful reasons you need to revisit or create a living trust right now if you're a single divorced parent in California. Number 1, your old plan probably gives your ex more control than you think. Before your divorce, you likely listed your ex as your primary trustee, beneficiary, or agent under a power of attorney. That made sense when you were married, but after divorce, those old designations can work directly against your intentions. If you don't update your documents, your ex could still be the person managing your money or making decisions if you're incapacitated. In some cases, they could even serve as trustee of your children's trust after your death. Updating your plan gives you control back. You can name someone you truly trust to handle assets, make healthcare decisions, and ensure your children are cared for according to your wishes, not by default through old paperwork. Number 2, your kids can't inherit directly, but you can protect them through a trust. Minor children can't legally inherit or manage money on their own. If you pass away without a properly structured living trust, a California court will appoint someone, possibly your ex or even a stranger, to control your child's inheritance. That person will answer to the court, not to your values or parenting approach. When you update or create a living trust, you get to handpick the person who manages your children's inheritance, the age or milestones when your children can access funds, and even how money can be used to support their health, education, and well-being. You're not just writing a plan, you're installing a safety system that operates exactly how you would, even when you're gone. Number 3, guardianship decisions need to reflect your new reality. Divorce changes family structure. Maybe you've moved, remarried, or built new support systems. The people who made sense as guardians 5 years ago might not be right now. California courts give strong preference to biological parents, but you still have influence through a written nomination in your will or living trust. You can express your wishes clearly, especially for situations where your ex isn't available or capable. Without an updated plan, your children could end up in temporary foster care while the court figures things out. A current estate plan ensures your children go directly to the people you trust without unnecessary trauma or delay. Number 4, life insurance and beneficiary designations must align with your trust. After divorce, it's critical to update beneficiary designations on your life insurance, retirement accounts, and financial assets. If you don't, your ex might still be listed as the beneficiary, and those designations override your trust or will. A living trust allows you to funnel these assets into a structure that benefits your children directly and securely. You can appoint a trustee who manages funds responsibly and uses them only for your children's best interests. That structure avoids court oversight and ensures the money you've worked for actually goes where you intended. Number 5, your peace of mind depends on knowing your plan reflects your new life. Estate planning after divorce isn't just about protecting money, it's about restoring control and peace of mind. You've already survived one of the hardest transitions life offers. Updating or creating your living trust is how you close the loop. It's how you make sure your kids are safe, your wishes are honored, and your future reflects the person you've become. California's probate laws are complex and unforgiving if you don't plan ahead. But with a current, well-drafted living trust, your loved ones stay out of court, your finances stay private, and your children stay protected under the guidance of someone you trust completely. If you're a single or divorced parent with minor children in California, your estate plan is not a box to check. It's a living reflection of your love and responsibility. Don't let an outdated trust or a missing plan decide your children's future. Take the time now to meet with an experienced estate planning lawyer who understands how California law handles these issues. The process is faster and simpler than you might think, and the peace of mind that comes from knowing your kids are protected is worth everything. Look, you've already proven you can handle hard things. This next step is about doing something powerful, securing your children's tomorrow, no matter what life brings. We're here if you need us.